Hello to all our friends at the Academy, and a warm welcome to those of you joining us for the first time. I am Professor James from IntlLaw Academy of International Law. The playlist I'm preparing for you will focus on the relationships among the subjects of international law. Together, we will explore how these subjects interact, what kinds of relations they form, and how international law regulates and organizes these interactions. If you're not quite ready to begin this new playlist, I recommend that you first watch the 3 playlists on the introduction, sources, and subjects of international law on the Academy's channel. These were prepared by the other professors of IntlLaw. But if you have already completed those and are ready to start this new journey with me, click on my playlist above to catch up on the previous videos if you want. Or let's dive into today's video by talking about friendly relations in international law. Let us begin by asking a fundamental question. Where do friendly relations in international law come from, and how have they evolved over time? The legal idea of friendly relations originates primarily from the UN Charter of 1945, drafted in the aftermath of World War II. The Charter laid the foundations for peaceful interaction among states, establishing principles such as the prohibition of the use of force, equality of states, peaceful dispute settlement, and non-intervention. Over time, these ideas were reinforced through customary practice and subsequent codifications, forming the backbone of what we now recognize as the doctrine of friendly relations. In the 1950s, the concept of peaceful coexistence emerged as a political doctrine, most notably articulated by the Soviet Union. The Soviets argued that socialist and capitalist states could coexist without resorting to war, despite profound ideological differences. While this was initially a political idea, it influenced international discussions on how states could interact peacefully and respect each other's sovereignty, paving the way for the legal recognition of friendly relations. During this decade, international law began to recognize mutual respect for territorial integrity and sovereignty, non-aggression and prohibition of force, non-intervention in internal affairs, and peaceful coexistence as a guiding principle. These early formulations created the foundation for the principles that would later be codified more formally. The 1960s brought decolonization, with many newly independent states entering the international system. The United Nations recognized the need to establish clear, universally applicable principles for state interaction. In response, the UN General Assembly adopted Resolution 1966, creating a committee tasked with drafting guidelines on peaceful coexistence and friendly relations. This effort aimed to formalize implicit norms and provide a legal framework to guide states in cooperation, dispute resolution, and peaceful interaction. This work culminated in 1970 with the adoption of UN General Assembly Resolution 2625, also known as the Declaration on Principles of International Law Concerning Friendly Relations and Cooperation Among States. Adopted by consensus, this declaration is treated in practice like a treaty, binding and widely accepted by states, even though it is technically a General Assembly's resolution. No state objected, and its principles are regarded as universally applicable. Importantly, the 1970 declaration is a practical translation of Articles 1 and 2 of the UN Charter. Article 1 outlines the purposes of the United Nations, maintaining international peace and security, developing friendly relations among nations, and promoting respect for human rights. And Article 2 sets forth the principles governing relations among states: sovereign equality, prohibition of force, peaceful settlement of disputes, and non-intervention. The Declaration takes these foundational articles and articulates them as actionable, universally recognized principles, creating a legal framework for peaceful state interaction. The Declaration enshrines 7 key principles: prohibition of the use of force, prohibition of the threat to use force, peaceful settlement of disputes, non-intervention in the internal affairs of states, duty to cooperate, equality of peoples and the right to self-determination, and equality of sovereign states and performance of obligations in good faith. Together, they form the core of friendly relations in international law. Each of them is interpreted in connection with the others, forming a coherent framework that guides the conduct of states. By codifying these norms, the Declaration ensures that friendly relations are both a legal obligation and a practical guide for international interaction. When we examine this historical development, a clear pattern emerges. Friendly relations in international law are both aspirational and practical. They are ideals guiding states toward peaceful coexistence, yet also legal norms enforceable through treaties, customary law, and the broader UN system. Understanding this evolution, from the UN Charter to customary practice to the Soviet discourse of the 1950s, through decolonization in the 1960s, and culminating in the 1970 Declaration, helps us appreciate how international law organizes cooperation, regulates conflict, and sustains order in the global system. Even today, these principles remain the foundation for diplomacy, treaty making, and conflict prevention, reminding us that international law is not just a set of rules, but a living architecture for peaceful coexistence. Among the 7 principles which we talk about in today's video, some are familiar to you, and others will be explored later in more detail. But to give you a deeper understanding of what friendly relations really mean, I want to focus on 2 particularly crucial principles that are essential for our analysis. The first is the prohibition of the use of force, or the prohibition of threats and resort to force. The second is the principle of non-intervention in the internal affairs of states. These 2 principles are central. They form the backbone of how international law ensures peaceful coexistence. The other principles will be explained in separate playlists by my colleagues as we continue along our journey through the Academy. But here, my goal is to delve into these 2 key principles, unpack their meaning, and explore the mechanisms that international law provides to enforce them and respond when they are violated. By focusing on these, we can really understand the core of friendly relations, because without respect for the prohibition of force and non-intervention, the entire structure of peaceful international interaction collapses. So we will talk more about them in our next videos, and I look forward to seeing you soon. Okay?